Hello everyone, welcome to Court with Krissy. Finally, this is the end of the jury trial. This video will take you all the way from the defendant taking the stand to the verdict. And do you smell a guilty verdict or a specialty strain of marijuana? Asking for the defendant. I hope you like it. Court with Krissy is now in session.
Remember that.
And after a period of time, at the time, were you married?
No, I was not.
Was Miss Lavalette married?
Yeah. Living
Question, relevant.
Response relevant.
Just to give a very brief background on their relationship.
Oh, that's not relevant, though.
Relative to the marriage, I find that it's not relevant. Objections sustained.
I moved it
We're not
straight.
consider that. Strictly from.
During the time that you were dating, did you and Miss Lavalette ever have time where you went out with your children?
Oh, all the time.
And was there a time that you didn't just date, that you lived in the same house?
Objection's leading.
I'm sorry?
The objection was leading.
Oh.
You may rephrase. Objection sustained.
During the time you were dating, how did that relationship progress?
Within a month, possibly less, she started coming over every single day. And she had week on, week off with her kids, with her two daughters. And she'd bring them along as well.
And she would stay at your house?
Yes,
That was just during the week?
during the week and the weekends up until Sunday afternoon, then she would take the girls home so that she could get them ready for school the next day.
Did there ever come a time when the two of you cemented more of your relationship and you did something other than dating?
I don't understand.
Was there ever a time that you did more than an overnight with Miss Lavalette?
Oh, yes.
And when was that? Let me direct your attention to December of 2023. What happened during that time in your relationship?
She started moving more of her items into my home.
Did she then close her house?
No, she kept it.
Have you been to her house before?
A lot of times.
And during that time, did you ever have a key to her house?
No, I don't believe there ever was a key.
Did Miss Lavalette have a key to your house?
Yes, she did.
Was there ever any mail going to your house? That was Miss Lavalette's.
Yes.
Do you remember when that might have started?
Probably 2 or 3 months in, she would order just like random things or her hair dye, and she'd have it shipped to my house.
Just miscellaneous items.
Pretty much like the stuff you buy off the internet real quick.
During your dating relationship, I'm going to try to do this chronologically, but I may jump back and forth. I'll do my best. During your dating relationship, I want to direct your attention to October of 2023. There was a time when you drove downstate to Belleville.
Correct.
To find To what? To find Miss Lavalette?
Yes.
And what happened during that time?
She said that she was going to.
Objection, hearsay.
All right.
Sustained.
Just tell me what you did, not what she said.
Okay. I contacted her friend that she was supposed to be with, and she was not with her, and her friend gave me her location where Shanna was.
And that was in Belleville.
Correct.
So you drove a little over 2 hours to the location where you believe she was.
Yes, at a hotel, and I parked next to her Jeep.
That seems like a really long time to make a trip to find your girlfriend.
Yes, I was very concerned because she was not replying to me or even answering a phone call.
What were you concerned about?
I was worried that something happened to her. I was concerned for her well-being.
And how long did you stay in the parking lot?
3-4 hours.
And you stayed in the parking lot. What was the reason? Did you see Miss Lavalette in her car?
No, I seen her Jeep, so I parked next to it and I sat in my car, and I just wanted to wait to talk to her, make sure everything was all right and what was going on.
Did you ever send any kind of messages or call her on the telephone?
Yes, I sent her text messages of pictures of her Jeep, told her I was outside, and then made a few phone calls. Then it was like 3 hours later, she messaged me and said she was going to come down and talk to me in the parking lot.
You say 3 hours later. Give us a time frame, please.
3 hours after I arrived at the hotel.
Do you recall what time that might have been?
I left my house at about 4:30-ish, so 9 or 10 o'clock, I would say, she finally got back to me.
And you say she got back to you. What happened then?
She came down to the parking lot and we met in the parking lot, talked, and he said,
Objection.
okay, I'm sorry.
Yeah, that's all right. You can't say what she said.
Right, right.
But what was the essence, if you can explain it without saying what she said?
We decided to get her items and to leave. So she went back to the hotel with me behind her. And then,
Was this willing that she did this?
Objection, move to strike because it calls for speculation.
She would have been answering him whether or not, it's not speculation, if he went with her up to the room to get her things. It's not speculation. She either followed or led or she didn't.
I'd rather allow counsel to rephrase the question. If it can be described as some physical aspect, that's fine, but
Okay.
saying whether she's willing without going into the mind of the witness is speculation. So you may rephrase.
Did you, thank you, Judge. You said that she went up to the room,
yes,
and were you with her?
yes, I was.
When you went up to the room, what was the first thing that happened?
She knocked on the door opened, and Mr. Kennedy was there, and him and I grabbed each other. I grabbed him around the collar of his shirt, and he grabbed my arms. We kind of pushed each other a little bit, raised our voices, and then he sat down, and I just stood there while Shanna collected her item.
Did you ever hit Mr. Kennedy?
Not at all.
Did he ever hit you?
Not at all.
Did you have a weapon with you?
In my car, I did.
And do you always carry the weapon in the car?
I used to because I had a CPL license and I followed that to a T for the rules on that. I was very adamant on those laws.
All right, so when you went into the room, you didn't have a weapon with you?
Correct, no weapon.
And then you came downstairs?
Yes. We came downstairs into the parking lot and we discussed where she would go,
Where she would go, meaning what?
home or my house. And I told her I told her it's up to her to decide, and she said she would.
Objection, I'm sorry.
That's all right. Did in fact, you go to her home after this?
She came to my home with me, followed me there.
And she stayed at your house. Now, this would have been in the early morning hours.
Yes, we laid in bed for about 3-4 hours talking.
Let's move to the incident where you had an interview with Sergeant Horst.
Okay.
Sorry, there's been so many police officers that it's hard to keep track.
I understand that.
During your interview, you started out talking with him, and you agreed to speak with him without an attorney present. You recall that?
Yes, I do.
And why did you do that?
I was in a manic episode.
What does a manic episode mean?
It's where you're mentally not stable in a way, where you can do erratic things, erratic thinking, like erratic actions.
And how long had you been in jail when he came to talk to you, if you remember?
That would have been my 7th day.
And you talked about a manic episode. Are you on medication?
I was until I went to jail and they cold turkeyed me off of my antidepressants. That was the highest dose for, and my Klonopin and my ADHD.
So you're on depression. What's the name of the medication?
I think it's a. May I look on my phone real quick?
Well, I'll help you out here. Do you remember, was it Zoloft?
No, it was not. That's what I'm on now.
Okay, but it was on some other kind of medication for
Yes, it was 200.
depression and anxiety.
Yes, it was 225 milligrams of that, and the Klonopin was 0.5.
0.5 milligrams.
Correct.
And how often did you take the Klonopin?
Every day.
And how long have you been on Klonopin?
Roughly 3 to 4 years.
When you went into the jail, did you explain about your medication?
Yes, I did, and I put electronic requests in to get my medications and to see their doctor.
And so when you had this conversation with the sergeant, you had not had any of that medication?
None whatsoever.
How many days would that have been?
That would have been the seventh day.
So in your estimation, from being on these medications for some time, do you believe that affected your ability to discuss?
Absolutely.
during your um, interview with the sergeant, you started discussing going to Mr. Stevens' house for grass clippings, but that wasn't true, was it?
Partially true.
Do you care to explain, please?
I originally was going to stop at Shanna's house to surprise her with a dinner date, and she was not there. I went,
You knew there was a PPO in place, though.
yes, but we were seeing each other no less than once a week to 3 to 4 times a week.
So you knew that by going to her house, you were violating the PPO.
Somewhat, because at the time I didn't understand what a PPO was, which is no excuse, but I should have researched it more for the consequences and the actual laws.
But you had been told about the PPO from another officer in the police department about the PPO being in place in May, correct?
Correct.
And she explained to you that you would have no contact with Miss Lavalette,
Correct.
but you continued to have contact with her.
Correct.
Did you always initiate the contact?
No. No, I did not.
Who else initiated the contact?
Shanna would contact me or come to my house.
At any time, did you tell her, no, I can't see you because there's a PPO in place?
No, I did not.
Why was that?
I'm not exactly sure. I think it was because
Speculation, if he says he's not sure.
Excuse me, response.
I think if he finishes answering the question, it will become more clear. Mr. Talisman,
I'm going to sustain the objection right now if you want to rephrase the question.
I'll rephrase the question. What were your feelings for Miss Lavalette?
I was in love with her.
Even though she had moved out of your house,
Correct.
even though she had a personal protection order against you,
Correct.
you continued to speak with the sergeant regarding the grass clippings.
Yes.
Why was that when you knew it wasn't true?
Because I was hoping that Shanna was not going to be there. So I had a valid excuse to pick up grass clippings for my garden that I wanted
That she was not going to be where?
at Dan Stevenson's house.
So before that, so we're going to go backwards a little bit. In an effort to maybe surprise Miss Lavalette, taking her out to dinner, where did you go?
I went to her residence because that is where the Snapchat message said she was at.
Okay. And you went into her residence,
Correct.
and even though you didn't see her Jeep up front,
Correct.
so you knew she wasn't home.
Yes, I thought maybe she ran uptown and was doing some shopping like she does sometimes.
And you knew that you were not supposed to be there because of the PPO, correct?
Correct.
Why did you enter the residence if you knew that?
Because there was multiple times I would be there while she was not there to help clean when I had my broken elbow because I was off of work. So I had time to help her out, and I would go there, pick up her house, clean the house, wash dishes, fix her sink,
trying to be helpful.
Yes,
When you went into the house and you said you didn't have a key, or did you say that? Did you
No
have a
key.
Why didn't you have a key to her house?
I've never seen her have a key herself.
So was the house then open?
It was unlocked.
And how is it that you discovered where she was?
I assumed because of the message was from Dan Stevens,
So you believed her to be at Mr. Stevens' house?
possibly, yes.
And then, was there a password to the iPad?
No,
Has there ever been a password?
no,
Have you ever entered or gone into her iPad before?
multiple accounts,
And with her permission?
yes.
Did she ever give you permission? Or, I'm sorry, did she ever tell you that you no longer had permission to go into her iPad after the PPO?
No, she never stated that to me.
Did she ever write a note saying you no longer had permission to get into this iPad?
No, she did not.
Did she ever tell you or write that you no longer were allowed in her house
No, she did not.
without permission?
No, she did not.
So after you left her house, where did you intend on going?
I intended to stop over at Dan's to see if she was there. And if she was not there, I was going to offer to buy grass clippings.
And when you drove up in the driveway, did you see her Jeep there?
No, I did not.
So you weren't sure if she was there or not?
Correct. I was not sure if she was there.
So you got out of your truck, it was the truck that you were driving?
Yes, ma'am. It was a 2014 Ram 1500 regular cab short box, blacked out.
Does it have a running board or anything?
No running board.
So you have to lift yourself up,
Pretty much jump. Yes.
because you're kind of short.
Yes.
So you got out of your truck and you went to the front door of Mr. Stevens' residence. Do you recall what happened next?
Yes, as I exited my truck, I walked around the front end of the truck and walked up to the door. And I raised my right arm to knock because my left arm was in a cast. It was in an awkward 90-degree position, rotated to the right side. And as I went to knock, the glass door opened up, and then I received 1 to 2 punches in the face. And on the second one, I tried to catch it, and I grabbed his arm, causing me to lose my balance and fall forward. And I landed in his doorway, and we started rolling around fighting, and then it just progressed.
And that would be in the kitchen area, correct? If you recall, there were table and chairs.
I don't recall from the photos I've seen, yes.
And did the fight progress?
Yes, it progressed very fast.
And did Mr. Stevens throw any punches to
Yes,
you?
yes, ma'am.
Do you recall whether or not you sustained any injuries?
Yes, I had a weird, disconnected cartilage in my nose. I had a puffy eye, and the back of my head was bleeding.
It was an abrasion.
I would say an abrasion because it did not need stitches or anything.
So you didn't seek medical treatment at all?
No.
When you were first hit by Mr. Stevens, how did you respond exactly?
I was in shock. And I pretty much just stood there.
Did you return the punch?
Not until after we were in the house rolling around.
So you did not open the door and go in first?
Correct.
So you fought for about how long?
I want to say maybe 5 minutes because I was completely out of breath and I was like wheezing and puffing and puffing.
And you're a shorter person,
Yes.
but you're also bulkier than Mr. Stevens.
Yes.
So you lift weights, so you're strong.
I was strong. I took a 9-month break from weightlifting.
When?
9 months before the month I broke my elbow, and I was just getting back into working out, and then I crashed my ATV and broke my elbow.
But there was a time when you were still lifting,
Yes.
even with a fractured arm in a cast.
One workout, I bought a specialty bar, a safety squat bar, so I didn't need both hands to hold the bar to squat, and I only did it one session.
What was your, when you went over there, what did you hope to accomplish, suspecting that Shauna was there?
If she was there, I was planning on telling her to never come around me again, and then I wanted my stuff. And she had
What kind of stuff did she have of yours?
a DVD and Christmas ornaments that were from me growing up that my mom gave me.
And your mom is passed, correct?
Yes, ma'am.
And during the time that you were in the house, did you have any conversation with Mr. Stevens?
Only when we were rolling around and it was just profanities back and forth.
Between the two of you?
Yes.
At any time, did you wonder where Shauna was?
Yes.
And where did you find her?
She came out of the closet yelling at me.
In the closet where?
In the bedroom.
And she was yelling at you. Were you asking where she was?
Only at the point when I smelled a certain odor from a specialty marijuana strain that I bought her.
Oh, so that made you think that maybe Shauna was there?
Yes, because I don't partake in it, but it had a very unique smell.
Okay, so she came out of the closet
Yes.
and she said something to you and she had a phone in her hand.
And
What happened then?
she had a phone and glasses, and then my voice was raised, and I tried talking to her, and she kept telling me I needed to leave. And in her left hand, she had her phone screen facing me with her glasses on the screen. And then she raised her phone and hand as like she was going to hit me. And I told her, don't hit me. And I held up my right hand and she handed me her phone and glasses, and then I dropped it at our feet.
Okay. And where did you see Mr. Stevens at this point?
He was sitting up against the bed, I do believe.
He was sitting up against the bed?
Yes, he was sitting on the floor with his back against the bed.
Did he say anything? I don't want you to tell me what he said, if anything. Just, was he talking to you?
I do not recall.
Were his eyes open, or was he laid out on the bed?
No, his eyes were open.
Was he communicating with Shauna?
Not at that time.
So he did not have his eyes closed.
Correct.
And after the phone fell to the ground, what did you do then?
I was told to leave. So as I went to leave, I picked up my glasses off the floor in the living room, I do believe, where that bookshelf was. And as I looked back, Dan was standing up, walking into the bathroom. So I picked up my pace, because I wasn't sure if he was getting a weapon or what was going to happen there. So I was in a flight or fight, and I was getting out of there as fast as I could. And I walked out to my truck, started my truck, went to take off, and I blacked out for a second, causing me to lose control of my truck. And I ended up out in the grass. And then I continued to leave. It was only like a second or 2 seconds that I blacked out for.
But it was enough time for you to lose control of your truck?
Yes.
Did Shauna say any additional things to you? Strike that. So previous to the time that, previous to the days leading up to July 2nd, had you spent any time with Shauna?
Yes, I did. The Saturday before, she called me crying, and I had my daughter with me, and she asked me to come pick her
Objection,
up.
relevant, or objection, hearsay. No, hearsay.
Did you, I'll rephrase.
Objection sustained by false. You may rephrase.
She called you crying. Did you then go to her house?
Yes, I went to her house with my daughter and picked her up and brought her back to my house.
That was the Saturday before?
Yes,
Okay. And did she stay with you the entire day?
she stayed the night, and we were intimate that night, or that afternoon, while my daughter was upstairs playing. We snuck off to the bedroom.
And then on Sunday, did Shauna stay during the day Sunday?
Up until around noon, then my daughter and I took her back to her house, and we continued to talk throughout the day. And when my daughter was picked up around 6:30, about 7 o'clock, Shanna came back over for the night.
Your daughter was picked up by whom?
My ex-wife, her mother.
Okay. So you have joint custody of your daughter.
Yes, I do.
So you stayed together, was it Sunday, all day?
All day.
It was later in the evening, rather, that she was there.
And she stayed that night. She brought enough stuff so she could get ready for work and leave right from my house to work.
Okay, that was on Monday.
That was Monday morning she left for work.
And afterward, or later on during the day, did you see her again?
On Monday,
Yes.
we continued to talk throughout the day, and she invited me over to bring one of my new DVDs that I bought off of Amazon. So I went over there around a little after dinner time and we watched the DVD. We started off on the couch and then the way her bedroom's set up, she was tired and she wanted to lay down. So we laid down, cuddled, and the way it's set up, the doorway, you can still watch the movie. We did that and we were also intimate.
That was the Monday before July 2nd.
Yes.
It would have been July 1st.
Yes. And I stayed the night there.
All right. And what did you do the next morning?
I got up with Shanna and had coffee with her, hung out with her while she got ready for work. And then I left just maybe half hour before she had to leave for work. And I went home.
And did you have any contact with Shanna the remainder of July 2nd after she left for work?
Yes, all day long.
What kind of contact? Not what she said, just what kind of contact?
It was through Snapchat, just I love yous, heart emojis, stuff like that.
And had you made plans for the evening during these Snapchat conversations?
We did not. She said she was at home relaxing.
Objection, calls for hearsay, move to strike.
Let me rephrase.
Objection sustained. Statement. The answer is stricken from the record, not to be considered by the procedure. May rephrase.
During the, she works till about what time?
I do believe it was 5 o'clock.
And you didn't have any further communication with her that day?
I did.
What time was that?
Up until like 20 minutes before I was at Dan's house.
Did you know, was she at home at that time?
It was claimed that she was at home in the Snapchat messages.
Move to strike. It's hearsay.
Objection sustained. Members of the jury not to consider. Stricken from the record.
I'll rephrase.
Please.
You had communication with her later in the day.
Correct.
And did you decide then to go to her home later?
We did not decide that. I decided to surprise her. That's how I was acting with my broken elbow. I would randomly take her to dinners or take her out to lunch.
And again, you knew that the PPO was in effect.
Correct.
And Shauna knew if by her action, well, strike that. Why did you continue to violate the PPO?
At the time, I believed that we still loved each other.
Later, you learned differently.
Correct.
The two of you had moved freely between residences.
Objection B.
May rephrase.
Did you often go to each other's houses?
Yes, often.
And did she have a key to your house?
That was asked and answered.
Sustained.
Did she often surprise you by coming over?
Yes. Sometimes it'd be 3 in the morning, or if she was out camping, she wouldn't be able to sleep. She would stop over They would be like 5 in the morning, have coffee at my house, and then end up going back to the campground.
You talked to Sergeant Morse. You continued to tell him about grass clippings and that you had no idea that Shauna was at the house.
Right.
Is that correct?
Yes.
You had no idea she was there?
I was not in fact sure that she was there.
When did you first find out she was there then?
When I smelled the odor of that marijuana.
So, other than that, you had no idea.
Correct.
Cross-examination.
Sir, it's true that you were verbally served by the Bad Axe police officer with that PPO on May 10th of 2024.
Correct.
It's also true you knew you were not supposed to have any contact with Shauna Lavalette based on that PPO.
Correct.
And is it true that you had your phone with you the entire time between July 2nd, July 3rd?
Yes.
Sir, you acknowledge that you were at Dan Stevens' residence, which is county, on the evening of July 2nd, 2024.
Yes.
Is it also true that you did not have permission to enter Dan Stevens' residence there at, on July 2nd, 2024?
Correct. I did not want to be in his home.
So can you follow my question? Okay. You didn't have any permission from Dan Stevens to be in that home, correct?
Correct.
You in fact were in the home, true?
Yes.
And there are two people that were lawfully present there, true?
True.
So on July 2nd of 2024, you were at Shanna Lavalette's house in the evening hours, correct? Is that correct?
Yes.
And at that time, when you were in her residence, she had not given you permission that date to be in her residence, true?
True.
When you were in her residence that evening, you had access to her iPad, true?
True.
And you intended to open it up, true?
Only after it connected to my internet and went off.
But you intended to open up the app when you swiped it, true?
Yeah.
And you did that without Shanna Lavalette giving you the permission to do that, true?
I never not had permission.
You follow my question?
Yes.
So my question is, from that date, did you have Shauna Lavalette's permission to get onto her iPad? You did use the computer service or the computer system for that, right? You get on there, you type it, you're using the iPad,
Correct.
true? You didn't have anything in writing or any verbal authorization on that date to access that iPad, true?
True.
So you acknowledge that there was a valid PPO in this case, correct?
Correct.
That PPO said that you shouldn't have or you can't have contact with Shauna Lavalette. True?
Correct.
And you can't be in a residence pursuant to that PPO. True?
True.
So on January 2nd, 2024, in the evening hours of July 2nd, you were in her residence. True?
True.
Secondly, the same date, down at Dan Stevens' house, you were in contact with her in that bedroom. True?
True.
The next day, July 3rd, you had contact with Shauna Lavalette outside her residence on South Silver Street in the morning. True?
True.
You were asked questions about your relationship. You said it was about 3 years long with Miss Lavalette. Is that correct?
Correct.
So then they start talking about 2022. That was I think the time frame. 3 years.
Yes.
You told Detective Sergeant Force that you had a relationship with Shauna Lavalette for about 3 years. That was in 2024 when he talked to you. True?
True. So now it would have been a lot longer.
You still consider yourself in a relationship with Shauna Lavalette?
No.
You would open Shauna Lavalette's house before with a credit card. Is that true? To get in there?
Yes, only because I was asked.
You were asked some questions concerning this October of 2023 circumstance downstate, down in Belleville.
Right.
How long is Belleville away by way of drive from your place?
Over 2 hours.
2 hours. You said you drove down there because you're concerned for Shauna Lavalette, right?
Right.
Did you call the authorities to indicate you were concerned?
No, I spoke with one and they said there was nothing they could do because she was of age.
You spoke to somebody.
Yes.
Who did you call?
I personally spoke with it was a federal agent. I don't remember.
Federal agent?
Yeah,
Where'd you get a federal agent? Where'd you go to?
it was around the area of Belleville.
You spoke to a federal agent in Belleville.
Yes.
So you drove all the way down to Belleville. You didn't call anybody in advance? You went down there?
No, I tried calling Shanna.
So where did this federal agent work for?
That I do not know.
I just looked up this federal agent.
He approached me.
Federal agent just walked up to you?
Yeah, he's seen how I was concerned, my demeanor being concerned, and
Where did this federal agent walk up to you for? Where were you at?
at the hotel.
He just randomly walked up to cars?
He was out in the parking lot and just walked up to me because I was pacing around.
You said you were sitting in your car waiting for Sean. 3 hours.
Well, I can't sit constantly for 3 hours in the car.
Well, that's what you said you did. On direct. We're asked questions, you said, I'm sitting in my car for 3 hours.
I said I sat out in the parking lot for 3 hours.
You didn't mention anything to Ms. Roberts in her question that some federal agent walked up to you that you do not know, just randomly asked, what's going on?
Well, she never asked.
All the time you're concerned with Shauna Lavalette's safety, right? That's why you said you went down there, checking her well-being.
Correct.
You're calling her and she didn't respond to you, right?
Right. Her friend was also calling her, the one that gave me her location.
We're just asking about you. Okay, just asking about you. So my question to you is, if you're so concerned, why did you let the air out of her tires?
Because I was getting ready to sleep in the parking lot. And I wasn't sure what was going on, and I wanted to talk to her.
So you let the air out of her tires?
Yes, because I had a portable air compressor with me.
She couldn't leave. If she wanted to leave, she wouldn't be able to leave, would she?
Not without me helping her.
Not without her having some contact with you or calling somebody else to inflate her tires. That true?
Yes, but I sat there and I wasn't going to leave with her tires being flat.
It was the same thing when you unhooked her battery cable that day?
Yes.
So you making sure she's not leaving unless she has contact with you. Is that true?
Correct. She was living with me at the time pretty much.
Is it true? You figured out she was there with somebody else and you were going down to confront her. Is that true?
No, I did not know until she spoke with me in the parking lot that she was with someone else.
Okay. If that's the case, then why would you let her air out of her tires and unhook her battery cable?
Your Honor, objection, that's already been asked and answered.
Objections.
You were making sure she wasn't going to leave. That's true?
While I was planning on sleeping, yes. I was not.
You gotta acknowledge that, you met up with this candidate when you went in the room. Isn't that true?
Correct.
So when you, go over to Mr. Stevens' house, you have an idea that Sean is at his place. Isn't that true?
I suspected it, but I was unsure.
You suspected she was there. You just want to go down and confirm it. Isn't that true?
Yes.
Because you can tell based on the iPad access you had.
Just from a message from,
From a message,
yeah,
right?
Dan to Shanna.
And so that's where you went down there. You went down there to confront Sean and Dan. Isn't that true?
If she was there, yes.
You want to confirm she was there. Isn't that true?
Yes.
So you go up to the door, to go to the house with the full intention of going to confront them, both Shanna and Dan. Isn't that true?
No, I was hoping that she was not there.
You're hoping she's not there. That's your testimony?
Yes, I didn't want her to be there. And
You don't see her vehicle outside, because the garage doors are closed. Isn't that true?
yeah,
So you're going to somebody's house to confirm whether or not she's there. Is that your testimony?
not to go in, no.
Not to go in. Not at all.
No, I had no.
Your Honor, objection, prosecution is badgering the witness.
Asking questions, cross-examination. I'm having witness.
I understand. Objection at this time is overruled, but continue with your question.
So, let me ask you this. When you went there, you said that you went to go knock on the door, right? You said you reached up with your right hand,
Yes,
and then you said the defendant is you. You're walking up to the door. It's a glass door, right?
yep.
You can see the person on the other side.
If you're looking, yes. But I had my safety glasses on and it stopped certain vision, certain peripheral vision, so I was mainly looking at the ground so I wouldn't trip.
Solid glass door, you saw that, right?
Yes. I was looking at the ground walking up to the house. I wasn't looking in the house.
Said that in your testimony that when you went to go knock on the door opened, and you were punched in the face, correct? Bridge of the nose.
Yes, in that area.
And from that punch, you went backwards, correct?
No,
You didn't go backwards.
no. No, my head might have, but I didn't stumble backwards.
This is an upward swinging door, true?
Yes.
So you're out on patio area when you go to reach for that door, true?
I was on it was on the right-hand side by the handle where I was gonna knock.
Sure, but you're still outside.
Yeah,
So you're punched in the face, according to what you said,
yes,
by Mr. Stevens, once or twice.
Right.
Correct? You know at that point that you're not wanted on the property. Isn't that true?
right, but the second punch, I grabbed his arm.
No, you know that you're not wanted onto the property, right?
Right,
But you go into his house. Isn't that true?
I fall into his house because of him.
You fall into his house.
Yes,
So then from there, you tell Detective Horst that you go right inside and you go straight ahead into a bedroom. That what your statement was to Detective Horst?
that's what I thought the house setup was.
You see that that's not the way that is.
I know that.
Made your way all the way back to the back bedroom. Isn't that true?
Rolling around with Dan, yes.
Rolling around with Dan. And you said something towards the end of saying that you were sort of helpless because you had this arm that you couldn't use. Is that
Yes,
right? But as Ms. Roberts was asking you, you're a pretty strong guy.
I used to be, yes,
Used to be.
yes.
You're not, when you say used to be, you're in a strongman competition, correct?
Years ago,
able to lift those big balls and put them up on top of the racks?
3 to 4 years ago.
Also, you can deadlift 600 pounds.
That would have been a year before Shannon and I got together.
But you do all these things. You exercise. You have an exercise place at your workout setup at your garage, correct?
Yes, but I have not used it.
So the video that Officer Deacons testified about you doing squats with your arm in a cast, that's not accurate?
That was after a 9-month break, and that was one session.
One session after a 9-month break.
Yes.
Is that going to go on your YouTube page that you have with your workouts?
Your Honor, objection, that's not relevant, whether he has a YouTube page or not.
So when you were punched in the face by Dan Stevens, according to your testimony, you could have just walked away, went back to your truck and left. Isn't that true?
I didn't have time to by the second punch. I tried to stop it.
Okay, so you have a second punch. That definitely tells you you're not wanted there. True?
True, without also being assaulting me.
You could have left, right? You're not fighting.
Not after the second punch when I tried to stop it.
Okay, so you go to stop the second punch as you're testifying here, and you said that you then fell into the house. That's your testimony, right?
Because I had a hold of his arm
Sure.
hitting me again.
Did you let go of his arm?
When I was on the ground, yes.
Could have got up and walked back out, got in your truck and left, couldn't you?
Not with Dan on top of me after that.
At no point could you have gotten up and went over and got in your truck and left. Is that your testimony?
Yes.
So Dan Stevens was on you the entire time,
He was throwing me around pretty good.
throwing you around the house.
Yes.
You know where the exit was, but you never used it until you were done. Isn't that true?
Until the fight was over, yes.
So your testimony was that this was a fight between you and Dan Stevens. That's your testimony?
Yes.
Isn't it true that you're the one that was the aggressor in this case?
No,
And isn't it true that you're the one that damaged Dan Stevens' house?
no,
Isn't it true that you're the one that knocked off his door for his bedroom as he tried to protect himself all the way onto the other side of the room?
no. Him and I went through that door.
Isn't it true you ripped off that closet door that's on his bed?
No,
Isn't it true that you punched that closet door 3 times
no,
and damaged the door?
no,
Now, isn't it true that you went and you flipped over his dresser in there that's in that bedroom?
no.
Saw the pictures of Dan Stevens, did you?
Yes,
We talked to Sergeant Flores when he had contact with you on July 3rd. You never mentioned to him that you had a cut on the back of your head, did you?
it was documented in my booking.
Do you have any proof here?
Not unless you pulled the documentation from Huron County booking
Do you have anything with a puffy eye from what we saw in the videos?
in my mugshot.
So did you tell that to Detective Force that you got cut on the back of the head?
I don't recall.
You saw the interview yesterday from you and Detective Force, correct?
Correct.
Where in there did you mention that you had a cut on the back of your head from puffy eyes?
I don't think I did there, but I did when I was getting booked.
But he asked you about injuries, didn't he?
Yes, and I was in.
What's the only thing you told him?
With my arm and nose.
Your nose. You talked about your nose. Never mentioned anything else. did you?
Right. I was in a manic episode because of no antidepressant.
Okay. So when you were in Sean Lavallette's house on July 2nd, the evening hours, you were still taking your medicine, correct?
Yes.
When you're out at Dan Stevens' house later that evening, in his house, you still were taking your medicine, correct?
Yes, up until
And July 3rd, you still were taking your medicine when you had
No.
contact with Sergeant Flores, right?
no. That was
You were.
that would have been the last morning.
That's the morning we had contact with, correct?
I did not have my meds that morning.
Isn't it true, sir, that you left in a hurry from Dan Stevens' residence before the police arrived?
I was told to leave, so I left.
Is it true you spun up the lawn at Dan Stevens' house?
Not on purpose.
You did damage his lawn on purpose.
Correct.
On your testimony about the grass clippings. So you're in this manic state, you said, and that's why you said grass clippings, right?
Partial of it is I did want grass clippings.
Because the manic phase had nothing to do with grass clippings. Instead, to Detective Sergeant Horse, you knew where this place was because there's a sign out front. True?
Yes.
It has a phone number on it, and also the vehicles that are driven around for the company also have a phone number on it, right?
I don't recall ever seeing phone numbers on it. But
You didn't say that to Detective Sergeant Horst at all? Phone number?
yes, I looked it up online.
You said to Detective Sergeant Horst, though, that you didn't believe that your ex was there, had no idea she was there. That was a lie, wasn't it?
Well, I was not sure that she was there. I was making a guess that she was there.
Because you used your iPad to see the message come up.
Yes, but it did not say anything about being there.
But that's why you said you already testified here, that that's why you went down there. One of the reasons was you believed that she was there. You wanted to confirm that she was or wasn't, right?
Yes, but I did not know for a fact that she was there.
You said, I had no idea that she was there. I think you told Detective Sergeant, right?
Right?
But you did have an idea. You just told his jury today. You believe she was there.
Thought she possibly could have been there because of the way the message was.
You didn't say that to Detective Sergeant Forrest, did you?
Don't exactly recall it.
Told Sergeant Flores that you and Ms. Lavalette have been broken up for about 3 months. Isn't that true?
Technically, yes.
And then you said that to Sergeant Flores that you see each other, but it's just not that often. Isn't that true?
Correct.
That wasn't true though, is it?
Well, not as often as we used to, which would have been every day.
Okay. What you told Sergeant Flores was that we see each other, but it's not very often. Isn't that true?
Yes, 1 to 3 days is not very often.
1 to 3, in your estimation, is not very often.
Correct.
And all these times that you're seeing her, those are all in violation of the DPO. Isn't that true?
Correct.
When you talked to Sergeant Flores, you kept saying X, my ex-girlfriend, X, X, X. So you knew she wasn't your girlfriend.
No,
Right.
but at the time she was acting like this.
But you kept referring to her as an ex-girlfriend. True.
True.
You also said the same thing to Detective Sergeant Forrest. True.
True. I was afraid to get Shannon in trouble at that time.
The order you were told is against you. Isn't that true?
Right, I thought it went both ways at that time, though.
You were told by the officer the order was against you. True.
Yes, but they
Okay,
also,
that's, not asking you for extra information. Answer my questions.
yes,
So you were asked by Detective Sergeant Forrest, there's going to be any messages between you and Ms. Lavalette. Remember that?
correct.
And you said no, but then eventually said at some point, just kind of regular lovey-dovey stuff, right?
Yes,
So my question to you then is, the message you sent to Shauna Lavalette the evening of July 2nd, fuck you, you POS. Is that a lovey-dovey message?
that was after the incident.
But is that a lovey-dovey message?
No,
Have an awesome day with your family. Hope your GF help you. Have a great time when Max takes your girls away. Is that a lovey-dovey message?
No,
Have fun with CPS or your shithole house. Fuck you and your fake ass. Is that a lovey-dovey message?
no,
You testified earlier today when you were asked questions by Ms. Roberts about how you would send messages to one another like I love you. You said you love her, right?
right. And she said she loved me.
So is that the kind of message you expect when you text good luck in life, fuck you?
If you went before those messages, you would see all that.
But you didn't tell Detective Sergeant Horse about these messages, did you?
I said there was no hate, there was
What?
there was no threatening or anything like that in them, but there would have been like arguments and stuff like that.
Yeah, you said arguments, something like, that was stupid, why did you post that? That's what you said, right?
Yeah, as an example.
But he asked you if there were any angry messages, threatening or angry messages, right?
I said there was no threatening messages.
They're angry messages.
Those ones are, yes. But if you went throughout that entire day, it would show that she was sending me heart emojis, telling me that she loved me and I loved her. That's
So
how.
when you found out she was down at Mr. Stevens' house, you were upset, true?
Yes.
And then you went down there to confront Mr. Stevens, true?
No, I was not going to confront Mr. Stevens. If she was there,
The angry message about goodbye, such bag. Your mama was wrong about you. You are trash with a finger flipping her off.
that was
That's
referring to my mom.
sure referring to your mother. Right? You're referring to your mother when you're talking to Shanna about that your mom was wrong about Shanna.
Yep.
You told Detective Sergeant Horst that you were never at Shanna's residence evening of July 2nd prior to going over to Dan Stevens. Isn't that true?
It is.
That's a lie though, isn't it?
Yes, I was afraid that Shannon would be in trouble for it.
All this about Shanna, you're afraid about Shanna being in trouble, right?
Yes.
How about when the Sergeant Flores stops you and said there would be any reason that some other jurisdiction would want to talk to you? Was there an incident from last night? Remember that question he asked you?
Yes, I do.
Yeah. And you said, no, I have no idea. Is that true? That's what you said?
Yes, because I did not know the cops were involved with it.
You didn't think the cops were going to be involved? When you get into a fight with somebody in their house? Is that your testimony?
Yes, I was never notified by the police or anything.
Well, if you stayed around, you would have been able to talk to the police and tell them your side of the story at that point, right?
Yes, but I was told to leave, so I left.
You didn't figure though that you should have gone as soon as the door opened and you said you were punched in the face? Could have left?
I didn't have a chance to because by the second punch, I was falling into the house because of Dan.
The cast you had on your arm was a hard cast, was it not?
Yes, it was.
The cast had to be cut off by a doctor. Correct.
No,
Doesn't have to be cut off by a doctor.
technically yes, but you can remove them.
Sure. You busted off on an object, right?
No, you can't break that stuff.
Can't break that stuff.
No, it's some kind of like fiberglass fiber nowadays. It's not a traditional plastic cast.
And there's no way you can unwrap it, as you said. Isn't that true?
That is incorrect.
You didn't have to break it to
No.
peel it off.
No, you just pick at the end like a piece of tape and peel it off.
But it's a hard cast. True. You talked to Detective Sergeant Horst He was asking questions about when you knew Shauna was there, right?
Yes,
You indicated to Sergeant Forrest that you didn't know Shauna was there until she came out of the closet. True.
true.
Today, you're telling the jury, though, that you knew that because you could smell marijuana. It's not special marijuana. Is that what you said?
Yes, sir.
Remember listening to the interview between you and Detective Sergeant Horst?
Yes. and
Where in there did you say that?
I did not because I
That's
was,
something new?
no,
Not new.
no, it's not new.
Did you tell that to Sergeant Flores?
No. Never questioned me on any of that.
You said today that Shauna had her phone in her hand with her glasses, right? And that then you said, don't hit me, and so then she gave you her phone and her glasses.
She had it
True?
raised
Is that what
up.
you said?
Yes, she had it raised up like she was going to hit me, and her glasses were on the black screen facing me.
Remember, sir, talking to Detective Sergeant Horst about that issue?
No, I do not.
You don't?
No.
You don't remember from the interview there that you said she was screaming and I told her she needs to stop. She raised her elbow like she was going to start hitting me and I told her, don't hit me. And that was the extent of it. So from that answer, where did you say that she had a phone in her hand ready to hit you?
Well, from that testimony, I did not.
No further questions.
Thank you. Redirect, Ms. Roberts.
Mr. Talisman, during the time that you and Shauna were together, did she ask permission to go into your house every time she entered?
No,
Did she ask permission to use any of your electronic devices every time?
no,
Objection, relevant, move to strike. How is it relevant as it relates to going into his house and using his electronic devices?
Respond.
The prosecution had indicated that Ms. Lavalette had said she did not give permission on that day, on July 2nd, to use that phone, to use her iPad. And so I'm trying to establish that she didn't ask permission every time she used his, and I was going to follow up with, did he have to get permission every time he used her iPad?
All right. Objection sustained. Answer is strictly from the record. Members of the jury not interested in the answer to the question. May I ask you next question?
During the time when you went up to the front door of Mr. Stevens' house, you testified earlier that Mr. Stevens had opened the door and threw the first punch.
correct.
He did not invite you in, did he?
No,
But you,
there was no word said.
so when you went up there, did he tell you, I'm sorry, let me rephrase that. When you went up to the front door, then the first contact that you had with Mr. Stevens was one of his fists at your nose.
Yes,
And you testified earlier that there was a second hit.
correct.
You testified earlier that you did not go over to Mr. Stevens' house to confront him.
Ask and answer, Your Honor.
Sustained.
While you were on the porch, You testified, or Mr. Rutkowski had asked you about, after you were hit a couple times, that you might have had time to walk away. Did you?
No, I did not, because by the second hit, when I had his arm trying to block it, I was falling over into the house.
During the time that Ms. Lavalette had the PPO in place, you testified that the two of you saw each other.
Objection, ask and answer.
Sustained.
Did you initiate the contact with Ms. Lavalette all the time?
Objection, ask and answer.
Did she?
That was-
Wait, just a moment.
That was asked on direct examination by Ms.
Objection sustained.
I'll try again. Did Ms. Lavalette ever initiate contact with you to see you?
This is
Yes.
objection. It's asked and answered. We've been down this road before.
Sustained.
Thank you for answering this. When Ms. Lavalette had the phone in her left hand with her glasses, you indicated that she raised it to hit you. Is that how the phone got on the ground?
Objection. He's already answered this whole series of questions. I mean, we can go through the redirect or direct examination all over again, but he's answered these questions.
I probably, we don't want to go over the entire direct examination because it's time too much. I'll withdraw the question.
Questions with
Thank you.
Cross?
Nothing.
Give me a second. Thank you. Robert, your next witness.
Defense rest.
Defense rest. Thank you. Mr. Rutkowski, rebuttal.
Let me yell, maybe take a break.
You intend to?
Stay for lunch, just because I don't know. I want to talk to Mr. Connie
Okay.
about a couple things.
All right. What we'll do, members of the jury, then, we will take our lunch break. We'll return at one. The defense has rested in this case, and Mr. Rutkowski, easy for me to say, wished to provide any rebuttal testimony.
No, Your Honor.
Very well. So the evidence and proofs have been entered in this case, and it is now time for closing arguments. Mr. Rutkowski, you may proceed.
Thank you, Your Honor. Well, to begin with, I would like to thank you for your attention during the course of the trial on behalf of the prosecutor's office. A lot of information, number of witnesses that testified. There's a lot of things to consider. This is the time for the closing argument. When you think about that, understand that a closing argument is a summation of, on behalf of people who we believe the evidence can show. As Mr. Mahoney had talked about before, this is one of those circumstances for review as the prior fact, determine what the facts are in this case. So my arguments, Ms. Roberts' arguments, they're merely that. They're arguments to have you understand our views in this case. So, and with that, because I carry the burden of proof, I get to address you twice. So I have the ability to address you right now, and then afterwards, Ms. Roberts can address you on behalf of the defense if she wishes, and then I can comment on her argument because of carrying the burden of proof. So as you remember from jury voir dire, the case in this situation has three separate circumstances that he had charged. And there is two charges in each of the files, and you'll be asked to consider them. The standard of proof in this case, as you've already heard, is beyond a reasonable doubt. It's a honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. That's important to remember because you'll be called upon to make decisions as to what you believe the information in this case shows to be the facts. And you can use your common sense when you're considering it. So to begin with, talk about the events that happened back July 2nd, July 3rd of 2024. The areas in which you heard testimony about, exhibits, is the city of Bad Axe and then the township of Austin in Sanilac County. So back at that time, from what you've heard, you have Mr. Stevens, who's living as he's down there that day. He invites a friend over, Sean Lavalette. How did Mr. Stevens know Sean Lavalette? Her brother there. We're down there, they're watching a movie, drinking some beer, and relaxing. So from the testimony, this will go into file 7178, which is the home invasion in the first degree. For that case, the elements for home invasion of the first degree. Defendant entered a dwelling without permission. Doesn't matter if he got his entire body inside. The defendant puts any part of his body into the dwelling without permission. It's enough to count as an entry. Well, I would submit to you that based on the evidence in this case, that element is uncontroverted. Even the defendant indicates he was inside Mr. Stevens' house on that date without permission. The second element is that when the defendant entered in, was present in, or leaving the dwelling, that he committed the assault to do great bodily harm, less than murder. Remember, we talked about this before. The intent is important. The third element is that when the defendant entered in, was present in, or leaving the dwelling, one of the following circumstances existed. A is that he was armed with a weapon, no proof of that. But B, another person was lawfully present. Even the defendant acknowledged that Dan Stevens and Shauna Lavalette were lawfully in that dwelling. So two of those three elements we submit based on the evidence proved beyond a reasonable doubt, because the defendant even acknowledged that. The second element is that entering in, present in, or leaving, there was an assault to do great bodily harm. I'll dovetail in because I'm going to talk about that charge now. So for the assault to do great bodily harm, the defendant tried to physically injure another person. That's the first element. Second, at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had that ability. And third, that the defendant intended to cause great bodily harm. Actual injury is not necessary. But if there's an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. This is alleged to have occurred, these offenses, in Sanilac County in Austin Township on July 2nd. So we know from the testimony of Dan Stevens and Shauna Lavalette that they're watching this movie. There's a lot of noise outside. So it says, big days here. Dan Stevens tells her, go hide in the closet. Thought there might be a surprise. And according to Dan Stevens' testimony, he gets up, and the next thing he knows, after he sees the defendant coming around the front of a vehicle, the defendant's coming through his door. Coming through his door, and then the fight is on. Dan says he retreated back to his room, used his shoulder and his hands to try to hold the door. You were able to see what the aftermath was of that circumstance. Some of the things I would point out to you. Starting with Exhibit 33. Table overturned in the residence when the officers first arrived at base. And then if you move on into the living room area, looking at Exhibit 38, shelf tipped over, tripod, telescope busted, laying on the ground. You look at 39, that's this end table that's overturned in the living room. And then you look at equals 41, which is the entrance to Mr. Stevens' bedroom. The door that should be on that frame is across the way. And what Mr. Stevens told you was as he was bracing the door, first there was a vital kit into the door, and you can see the hinges, or at least the screws on the top giving way. Next thing you know, it busted through, and he didn't remember much after that. He said he remembers feeling like he was being struck in the head, and then he tasted blood. You look further into the room as to what was going on, and then we look at actually pictures 43 and 44 show you those hinges that were there, screws still in the hinge, and 45 is a close-up of one of the screws in the hinges. And we would argue to you that takes a lot of force to knock the door off when it's being held on the other side. And then you have all the blood in the room. 47 shows the blood at the bottom of the casing. You can see blood in 48. Within all those clothes that were strewn about on the floor. 49, dresser overturned. 51. 51, a door, bifold door that should be on the closet, because that's where Mr. Stevens said it was. Now laying on his bed with 3 punch marks to it. Mr. Stevens indicated that wasn't like that before the defendant showed up. None of this stuff was like that before the defendant showed up. 53, just the close-up of that door on the opposite side of the room there, where it should have been on its hinges. And then you look further. 56, showing you the blood on the wall. That then leads into the bathroom. And there's pictures 59, 60, 61, showing you the blood that's in Mr. Stevens' bag. Further on, 63, 64, you have blood in the toilet. You look at 66. A lot of blood on the carpet. You know from the testimony, Mr. Stevens had a cut to the back of his head. And that even the officer said when he was there, Deputy Washi noticed that. Dr. Laker testified about that. I remember Dr. Laker's testimony. He indicated that they did scans of Mr. Stevens, and he had to be transferred down to Lapeer for a brain bleed. He said he was contacted by the analyst doing the test for Mr. Stevens. I believe that what you heard was that he said there was a critical message to come through. So when we have a critical message, we have to make face-to-face contact and discuss that. Based on what he saw then, he sent Mr. Stevens on for further treatment down at Lapeer because of the injuries to Mr. Stevens. So then we talk about, well, who did it? We know from Mr. Stevens' testimony, he'd indicated that the defendant comes into his house uninvited. When he does that, Mr. Stevens retreats back to his bedroom. The defendant goes through the door. Mr. Stevens is struck in the head, and then he told you what he remembered. We know from Shauna Lavalette, she heard a vehicle. I think it's Dave. She goes and hides in the closet. And then here's the defendant coming into the residence. Where is she? Where is she? Wants to know where she's at. Keeps calling. Shauna Lavalette testified about all the noise she heard. the crashing, the breaking of items. And then from there, she said she hears either a snoring or lack of breathing because of her occupation. And she wants it to stop. She says to the defendant, I'm here, I'm here. And she's in the closet. The defendant comes in front of her and starts yelling at her. Yelling at her, he's upset, he's angry. And we see the anger when you look at what happened to the closet door with the punches. I submit to you that that shows intent. The fact that the defendant struck Mr. Stevens so much around the head that when he's sent to McLaren, he has to be transferred out because of his injuries. These are all things you can take into account when you look at assault with intent to commit great bodily harm. When we look at the defendant, okay, well, part of what you've been instructed on is motive. Motive doesn't always have to be something that you can consider. It doesn't have to be proven beyond reasonable doubt, but it's something you can think about. So why would the defendant do that? Well, what's telling is the defendant was upset that somebody was spending time with his girl. Even though he says he had a girlfriend, that's what he tells the detective force. He's going, I'll believe this is my girlfriend, I'm getting grass clippings. Stop over there and get some grass clippings at 9 at night, sometime after 9 o'clock. That's when this alleged to have taken place, after 9 p.m. Call comes in at 9:17. So what else do we know about Mr. Talisman? We know from the testimony that Miss Lavalette had another individual down in Belleville, this Mr. Kennedy. What did the defendant do? Drives 3 hours, goes all the way down there. He's so concerned about her safety, he drives down there to talk to her, wants to make sure she's all right. But he waits out the parking lot for 3 hours, and just in case, on the off chance, she might not stay around, he lets the air out of her tires and unhooks her battery cable. Well, he loves her. Right? Well, I submit to you that's not love, that's control. We talked about this in jury voir dire. Person that's very possessive of another individual. And I would argue to you that that's what we have here. So we have this circumstance, and remember what Ms. Lavalette said about that situation. She said the defendant followed her into the room, took Mr. Kennedy by the shirt collar, put him up against the wall, and said, leave her alone. Leave her alone. Now that's, we would argue to you, powerful information as it relates to showing intent in this case. But there's more. And what did Mr. Stevens testify to? Mr. Stevens had testified to that in December of 2023, he's coming home, drives to the driveway, there is a car. This tan and black vehicle, Impala that's sitting there. Guy rolls down his window and says, you Dan Stevens? He said, yes. Person walks around, who is that? It's the defendant. Walks around, leans into the vehicle. As Mr. Stevens said, breathing pretty heavy, appeared to be upset. Said, stop talking to Shannon. Stop talking to Shannon. Okay? Let that sink in. Then he said further as to why. If I have to come back here again, it's not going to be good. Guess what? It wasn't. When the defendant showed up again at that residence, it wasn't good. Because the result is what you see here, with Mr. Stephen bloodied from the assault that had taken place by the defendant. Defense has argued that I'm just defending myself. Two things I point out to you on the self-defense. As self-defense is something that I have proved beyond reasonable doubt didn't happen. So the burden is on me to do that. Some of the things you'll be instructed. First, the defendant, he honestly and reasonably believed he had force, used that to protect himself from an eminent use of force of another. Okay? Well, let's look at what the defendant did. He put himself in that position. He came there. And as I asked the question, he could have walked away. He could have went back to the truck. No. Couldn't. Why? Because somehow when he's punched, Instead of falling back or staying where he's at, he falls into the residence. He goes into the residence. And I would argue to you, laws of physics do not add up that way. But he's inside the residence. At any point in time, he could have left. No, no, no. He wants you to believe from his testimony that all along, he's got Dan Stevens is on top of him, and in essence must be pushing him down from the kitchen area into the living room, knocking all this stuff down as he's taking him from room to room, and the defendant can't get out, can't do anything because Mr. Stevens is on him. All the while, the point being made, oh, Mr. Stevens must have been drunk because he had so much beer to drink. I argue with you that that's not the case. It's not self-defense. The defendant went into that residence to look for his ex-girlfriend. And he wanted to send a message to Mr. Stevens because last time he was there, apparently Mr. Stevens didn't get the message. So he's going to send it to him this time. And we see the results from the photographs. Third, the right to defend yourself only lasts as long as necessary for protection, and fourth, the person claiming self-defense must not have acted wrongfully to bring on the assault. Where he's not supposed to be. If there's any indication that you're not wanted at a place, if somebody pushes you or punches you, according to his testimony, that's a clue. That's a clue that you're not wanted there. Leave. As it relates to the telephone interference, that charge says that the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or any electronic media. And it doesn't matter whether the communication was actually sent or received. The second element for that is the defendant did willfully, maliciously. That means means that the defendant did the act on purpose with the intent to prevent, obstruct, or delay the communication. What do we know from this testimony? This is from Shauna Lavalette. She indicates she's in the closet. She's trying to call the authorities because of what had happened. The defendant is yelling at her, grabs her phone from her, throws it in the closet. Now, it's not a super huge closet. She's able to retrieve it. But we would argue to you on behalf of people that the defendant did prevent that communication from being sent when he took the phone. And secondly, he did it with the willfulness or maliciousness, meaning that he did it on purpose. He intended to prevent her from calling, and then he left. So, we talked about a whole series of events. We talked about what you saw through the testimony and the exhibits, and what happened out there inside the house. Then the defendant leaves. And I think this is important when you look at it, and it would be people's exhibits. This is just some of them. If you look at people's exhibits 21, you can see the tracks in the driveway starting to go into the grass. And then if you look at further at people's 22, the ruts in the driveway itself, 23, and 24. How deep those ruts are from the defendant, as Deputy Schmidt had said, did a donut out there to get out. It takes a lot of force, acceleration to make those marks and to get out. And that was the testimony. Want to get out of there in a hurry. Why? We would argue to you because he knew the police were coming. So he wanted to leave. And there's an instruction that you'll be asked to consider. It's an instruction concerning flight. It says that, the exact wording for you, evidence the defendant had ran away from after the alleged crime. Doesn't mean that it's guilt. A person may hide or run for innocent reasons, panic, mistake, fear. However, a person may also run and hide because of consciousness. You must decide what evidence is true and whether it shows the defendant had a guilty state of mind. We would argue that that's the case. Further, we're talking about the defendant being down there in his intent. I think it's important to remember the conversation that Detective Sergeant Forrest had with the defendant. He's just doing the interview, asking him questions. Well, why are you out there? I'm getting grass clippings. 9:30 at night or 9 that doesn't make any sense. Well, I was going to go over there. I was going to stop. and put a knock on the door, knowing maybe I would have gone to my girlfriend's and come back, but that's what happened. I think it was really telling then, is if you look at the messages that were sent, because that was pretty big. Detective Sergeant Moore said nothing about your phone is going to say anything with angry or threatening text. Oh, no, no. Well, look at People's One as to what the defendant had said. You read them for yourself. That, I would argue to you, is not a text that is lovey-dovey. That's the word he used to Detective Sergeant Morris. We send lovey-dovey stuff. I would argue to you that these messages are not lovey-dovey. People's One, People's Two, People's Three. Got the finger flipping her off. These are not angry, or these are not texts that would show being lovey-dovey or that, it's just loves her. No, these show anger. And they also, when you look at the testimony from Mr. Talisman himself, he believed that she was down there. He wanted to confirm that she wasn't. So he went down to Sanilac County to go and confront Mr. Stevens, we believe according to the testimony. And he went down there with that purpose. Grass clippings had nothing to do with it. He wasn't being truthful with Sergeant Horst with that. He wasn't being truthful with Detective Sergeant Horst when he's talking about other things involving this circumstance. Look at the interview itself. Went to Walmart. We know from the evidence of the phone dump where the defendant goes. Anything that would show that your phone would be over at your ex's house. No, not at all. No. You look at the interview from the detective sergeant and the defendant. But he was. He lied to the police. Among other things, this is one of them. And this is one of those that, say, well, I told a federal agent about this, or I told that. This is phone data that you really can't mess with, because he indicates the phone is on him the entire time. So the phone's on him, the phone's traveling. So where do we go? Well, we go from the defendant's house, shows him going over to Bad X, and where did Officer Deacon say he stopped? Which is Miss Lavalette's house. And then it goes after a period of time, because there's so many data points as Detective, or excuse me, but Officer Joy, the data points there were at Miss Lavalette's house for a while. And then they go directly from there down to Sanilac County. Time frames match up exactly with what the testimony was with Miss Lavalette, Mr. Stevens, the 911 call, when the defendant was there. Now remember, the defendant says, oh no, I was there about 6 o'clock. 6 o'clock, yeah, I still lay out, I was walking my dog, 6 p.m. Once again, a lie. He wasn't there. Even when the detective brought up to him, this call comes in after 9. You got any explanation for that? Well, that makes no sense. And once again, how many times during the cross-examination does the defendant say, well, I didn't want to get Sean in trouble. I didn't want to get Sean in trouble. I would argue to you, he didn't want to get himself in trouble, and that's why he lied to the police. So that is as we talk about the home invasion first and the assault with great bodily harm. Let's look at Ms. Lavalette's house. Oh, I should say, in that same file, the interference, we would argue to you, those elements have been proven beyond reasonable doubt as well. So we look at home invasion second degree. Defendant entered the dwelling without permission. Once again, same type of definition. It doesn't matter whether the defendant got his entire body inside. If the defendant puts any part of his body inside the dwelling, that's enough. And the second element is that when the defendant entered, was present in, or leaving the dwelling, he committed the offense of unlawfully accessing a computer system. So what do we know from the testimony on this charge? Well, Shauna Lavalette said that the defendant, yes, they were dating, yes, he'd been over the house at different times, but she also indicated that she had not, during this time frame, allow the defendant to be at her residence without her being present. So he did not have permission to be in there. He even acknowledged that he did not have permission from Sean Loveland to be in that dwelling, her dwelling, on that date. And second, the defendant entered in, present in, or was leaving, committed to being unlawfully accessing a computer system. So let's look at that charge for the unlawful accessing of the computer system. First element, defendant accessed a computer or computer program system. We had a testimony from Officer Deacons, who said that when he did the data dump on the phone and on the iPad, he could tell that the iPad was accessed from Ms. Lavalette's residence, and during the time frame he told you about, at the same time frame that Ms. Lavalette's phone was down in Santa Fe County, so it wasn't her. He also testified about the phone data from the defendant's device that put him at that address at the time that the iPad was being accessed. The defendant himself indicated when he testified he accessed the computer system. He said he did so intentionally because he saw this message pop up, so he swiped over. He eventually did that. Third, he did so without valid authorization, and he didn't have authorization from Ms. Lavalette to do that. And one of the things you will hear is that from there, the fourth element, the defendant did so and used that service or computer system. And it's clear he did that to get on Snapchat, get on Facebook, on Ms. Lavalette's iPad. Deciding whether he acted without valid authorization for the computer program or system, you may consider, but don't have to. And you can infer he didn't have authorization if the defendant's access to the computer was intentional, except if there's written or verbal authorization. There's nothing in this record to indicate that there's written or verbal authorization by the owner, which is Ms. Lavalette. She testified here. So, based on that, we would argue to you we've proven beyond a reasonable doubt that count, and that is the second element for the home invasion second degree. The third file. Third file is the aggravated stalking charge. First, the defendant of the aggravated stalking committed 2 or more willful, separate, non-continuous acts of unconsented to contact by Ms. Lavalette. Court will define you unconsented to contact means the defendant initiated, continued to contact with Ms. Lavalette without her consent, including the following: appearing within her sight of Ms. Lavalette, approaching Ms. Lavalette in public or private, appearing at Ms. Lavalette's workplace, home, entering or remaining on the property owned, leased, or occupied by Ms. Lavalette, contacting Ms. Lavalette by phone, sending electronic communication or mail to Ms. Lavalette, placing an object or delivering an object to the property owned or leased by Ms. Lavalette. That's the first step. Second is the contact would cause a reasonable individual to suffer emotional distress. Third, the contact caused Ms. Lavalette to suffer emotional distress. Fourth, the contact would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, the contact caused Ms. Lavalette to feel terrorized, frightened, intimidated, threatened, harassed, and molested. The last one is sixth, at least one of these unconsented to contact was committed in violation of the restraining order. The defendant had actual notice. So what do we have proof on that aspect of it? Well, we know that there was a valid PBO. You have the ability, when you go back, to look at any and all of these exhibits. You just ask the court, they will allow you to look at that, the body cam footage, any of this stuff. But this PBO, uncontroverted, it's valid. And what does it say? It says right here, it's ordered David Walter Talisman II, the defendant. He's ordered not to have contact with Ms. Lavalette. So, the questioning suggests, well, there's contact all along. Orders against Mr. Talisman, and he's violating that order. And the three, well, 2 or more, so 3 circumstances we would point to is 1, July 2nd, 2024. defendant is at and in Miss Lavalette's house. He's not supposed to be on the property. He's not supposed to be there. He acknowledged he was there during his testimony. He acknowledged he was in her residence. That's one. Second one is that the same date, as he's looking for Miss Lavalette, he drives down to Dan Stevens. He enters without permission into Dan Stevens' home because he's looking for Miss Lavalette, and he eventually comes in contact with her when she's in the closet. She said about how far he was away from her. Within a matter of feet, yelling at her. She's having contact, direct contact. That is a violation also of the DPO because that is a separate circumstance. And then third, the next morning, when the defendant is driving down, Miss Lavalette by chance turns off of Thompson Road and she's followed. She recognizes the truck, pulls over to the side. Miss Lavalette goes around him, drives up to her house, pulls in the driveway. Defendant pulls along by the sidewalk, gets out and asks for some DVD. It's like, well, I was just trying to get the DVD back. Well, that, once again, that is contact that he's not supposed to have. So then we look at, would a reasonable person suffer emotional distress? Well, we know from these circumstances that the night before, Ms. Lavalette was scared of the defendant because of his actions. What he did to Dan Stevens, she had no idea what he was going to do to her. And the next morning, when he shows outside her house, she calls the police right away. So we're not doing this. And she calls the police. She is continually afraid of the defendant at that point. So I would submit that we've shown and proven that that element has been met by a beyond a reasonable doubt standard. And then third, she did suffer it because, once again, she testified as to her fear of the defendant. And also remember, I mean, you get this individual who's following her down to Sanilac County, goes to confront Mr. Stevens in December of 2023, leave my woman alone, and then goes down to Belleville earlier than that to confront whoever she was with there, which is Mr. Kennedy, leave her alone. Now, the common theme. And he would say, well, I love her, I do things for her, you know, she's my woman, she's my this, she's my that. Yeah, once again, who let the air out of somebody's tires on hooks or battery cable if you love them? I just wanted to make sure I talked to him. Well, I believe that all ties in, and we would argue that the evidence shows that this is the emotional distress for Ms. Lavalette. Fourth, it would cause a reasonable person to fear, terrorized, frightened, intimidated, molested. Once again, same type of facts we would argue support that. And fifth, that caused Shauna Lavalette to have the fear of terrorizing, frightening, intimidating, threatening, harassing, or molesting. Once again, same thing. So I would argue to you that we've proven the aggravated stalking case beyond a reasonable doubt. Lastly, use of a computer to commit a crime. For here, this crime, it says first, the defendant committed the crime of aggravated stalking, which has been defined for you, and the judge will define aggravated stalking. Not necessary, however, that anyone be convicted of that crime. Second, the defendant intentionally used a computer to commit that crime. So, using a computer is any connected, directly, interoperable, interactive device, equipment, or facility that uses a computer program or other instructions to perform a specific task, including logical, arithmetic, memory functions with or on computer data, computer program that can be stored, retrieved, altered, communicate, result in the operation of a person, computer program, computer system, or computer network. What that all mean? Well, it means to use the iPad. So we would argue to you. He got on this iPad, which is a computer system. He found out where Miss Lavalette was. He believed she was there, and he went down there to confront Miss Lavalette and Mr. Stevens. Because as Mr. Stevens testified, when it said, I have to come back again, won't be good. Leaving with this, when you're looking at the elements for the offense, you think about this. Think about the injuries. Who had injuries? Mr. Stevens on the left, and the next morning, Mr. Talisman. Based on that, we would ask that you find the defendant guilty of all charges. Thank you.
Ms. Roberts, your closing argument.
When I first talked to you on the first day of trial during my opening, I said that you were going to hear different versions of the facts. One is the prosecutor, the other would be from the defendant. And that's exactly what you've heard over the last few days. We're going to go in a little bit different order than what Mr. Rutowski talked about. Hopefully you'll be able to follow me. Let's first start with home invasion second, which is where David went into Shauna's house because he wanted to surprise her at dinner. That was his testimony. His testimony said that they had spent the last couple of days, 2 or 3 days together, and they had spent time during the day, and that they also were intimate all those nights. So then there was a question about whether or not they had, or he had permission to go into her house. Well, there was never any written permission or other permission that she gave, or lack of permission that she gave to Mr. Talisman, saying, even though we spent the past 2 to 3 days together, and even though we had sex together, you're not allowed at my house. I don't want you coming into my house, nor are you allowed to use any of my electronic devices. Prior to this, they had both had access to each other's devices and to each other's house without any permission being granted or rescinded. It would be like if you have some kind of relationship where you are seeing someone and you're intimate with them. Do you say to them, oh, by the way, you don't have access to my computer? And even though you've been to my house in the past, today would be July 2nd, you don't have permission to come into my house, even though that permission had been for both of them prior to this incident. There was never any kind of written communication that Shauna gave to David regarding the iPad. There was never any produced by the prosecution. There was no notice on the door at her house saying, by the way, David, you're not allowed in my house and you're not allowed to use my computer. He came over there to surprise her by taking her out to dinner. And what happened was the iPad happened to go off because he had previous access to that. He happened to look at it and found out where he believed she was. I submit to you that that was not an unlawful entering of the iPad. Permission had been carte blanche for both of them. Again, as far as the access of the iPad, he had no idea what the iPad would show, but it had also connected with his phone. And that's the reason that he accessed the iPad. He found out that through the messages, that she probably was at Dan Stevens. And he decided to go over there to find out whether or not she was. It was David's testimony to the sergeant horse that he was going over there for grass clippings, and David testified today that that was not true, that he was afraid that he would get Shauna in trouble. So therefore, that's what he told Sergeant Horst. However, today, he testified to something entirely different. That's where I follow along with what I said about the two different versions of what went on. So Mr. Talisman decided to go over to Mr. Stevens' house to see if, in fact, that Shauna was there. When he got out of his truck to walk up to the front door of Dan Stevens' house, he didn't even get the opportunity to knock before the front door opened, and he was hit in his face. And the first hit landed on his nose. A second hit came, and that's when David decided he was going to fight back because he wasn't sure what was coming next. He had no idea what was going on. He didn't expect someone to open the door and punch him in the face. So what he did after the second punch was to punch back. And if you've ever been in a fight, or if you've ever seen a fight, it's not like you can stop in the middle of it and say, well, you know what, I know I have a duty to retreat, so I'm going to turn around and I'm leaving. Of course he wasn't welcome there. That's what the punch in the face told him the first time when he went to the door. The parties continued to fight, and during the fight, what happened was David fell into the house. Think about it, use your common sense. If you're in a fight, you're unsteady on your feet, you don't know what's coming first or last, or whether someone has something with them, like a weapon. So when Mr. Talisman fought back, and they catapulted. It's like, which came first, the chicken or the egg? There's no way to tell. The fight had ensued. They fought into the house, went into the kitchen, chairs were knocked over, went into the living room, other stuff was knocked over, and they ended up in the bedroom. And that's when they both went through the bedroom door. It wasn't David coming into the house and punching the bedroom door. How was he to ever know that Dan was behind that door? He had no idea. According to the prosecution, David had a duty to retreat. Where was he going to retreat to? At what point? There was no point. He kept fighting because he was afraid of what might happen next. He meaning David, only used the necessary force to repel Dan's punches. Dave did not use any weapons. He did not pick up any lamp. He didn't pick up a chair to hit Dan over the head. And remember, David only had one good arm. Now, granted that he is a bodybuilder or a weightlifter, but consider this, it's like a one-arm paper hanger. You're pretty limited if you've got your entire left arm in a cast. Of course, both of them would be unsteady on their feet, and there would be a lack of coordination, especially with Dan Stevens, because he had had quite a few beers that night, and he testified that it was 2 Hard Ale, which is 7% alcohol content. During the fight, Shauna heard what she thought was loud snoring. And so she also heard, "Where is she?" which was coming from David. So she came out of the closet And of course, she was upset. She had heard all this fighting and stuff going on in the other rooms. David's testimony was that she had her phone in her left hand along with her glasses. And David was very upset when he saw her. Of course, he would be. I mean, he was over there, he had just been into a continual fist fight. And he was angry that she was there, but he didn't hit her. She, though, took her phone in her hand with her glasses and tried to hit David with the phone. That's when he blocked her punch and the phone fell to the floor. So he was not malicious in knocking the phone out of her hand, nor was it a willful punch. It was something that just happened. He didn't try to stop her from calling 911. When he left the residence, he too was a little confused. He got into his truck, and there was testimony about the ruts that were in the front yard. David testified earlier that what happened was he had left out for a minute, which would be understandable with the fact that they had just been in a 5 or more minute fight. And because he had lost temporary consciousness, the truck took off. When he realized what was going on, he straightened it out and left. Was he afraid? Well, yeah, I'm not sure who wouldn't be, considering that there had been a fight there. But he never touched Shauna at any time. As far as the violation of the PPO, unfortunately, it prohibits David from being around her. But in using your common sense, it just doesn't make sense that that's the only person that should be involved. During the interaction with Dylan Kennedy in Belleville, Michigan, David followed Miss Lavalette up to the room to get her stuff. David never, ever hit Mr. Kennedy. They shoved each other, and Mr. Kennedy sat on the bed, and Mr. Talisman just told him to stay away from Shauna. That was it. He had no weapon or anything else. He never punched him. There's a couple of other matters. If you recall, David never physically hurt Mr. Kennedy, nor did he do anything other than grab his shirt. The testimony has been very convoluted. And there are a lot of cases, and it's going to be difficult for you to sort through a lot of it. You have to look at the credibility of the witnesses and what they said or what they didn't say, as far as how they said it or what they didn't, or if they didn't have a certain reaction that you think that they should have. With the home invasion second degree, again, he did not know that he did not have permission to enter. There'd be no reason for him to think that, considering the fact that they had been together for 3 days previous. As far as accessing the computer system, again, he had had permission. In the past, there was no reason for him to believe that he no longer had that permission or that it was withdrawn. There was no sticker on the iPad that would confirm that. As far as first degree home invasion, Mr. Talisman responded to a punch. He didn't enter on purpose into Dan Stevens' house. There was a couple of punches that he received, he fought back, and in a fight, people lose their balance, and he fell into the house. He never intended on doing anything more. As far as the assault with intent to do great bodily harm, less than murder, this was a self-defense by Mr. Talisman. And he never had the intent to go over there and to get into a fight. He knew he only had one good arm. Granted, again, he is a weightlifter and a bodybuilder, but he also had testified that he hadn't done that for some time. So he wasn't able to lift that 600-pound ball like he had 8 years before the incident. It is our position that based on all of the evidence that's heard, and that the evidence that the prosecutor and the defense has submitted, that the people have not proved their case beyond a reasonable doubt, and ask that you return a verdict of not guilty on all charges. Thank you.
Thank you, Ms. Roberts. Rebuttal argument, Mr. Acosta.
Thank you again. Just want to reiterate what I had said at the beginning of my closing, and that was that my argument is not evidence. Ms. Roberts' argument is not evidence. We just are giving you our perspective of the case. You will determine what the facts are in this case. So in answering some of, or at least addressing some of the argument that was raised by Ms. Roberts. So Ms. Roberts said, well, there's two different versions of the facts in this case. And there are. I mean, when you look at it, you have two stories. We would argue to you one that actually happened, one that Mr. Talisman, the defendant, has made up. There's one witness in these proceedings has been shown to repeatedly lie about things and admitted to some of his lies. That's the defendant. When you look at this circumstance as a whole, we start off the way that the case numbers fall, they don't fall in correct order. But really, you start there on where the defendant goes over there. And he goes in to Ms. Lavalette's house, knows he's not supposed to be on her property pursuant to the PPO, accesses her computer system. But as he said, he swiped over when he saw this message come up. He had pretty strong suspicion where Ms. Lavalette was. And he went down there. I think if there's anything that I would argue to you that this evidence shows is a very controlling relationship by the defendant. And I'm not sure how else to argue that point, but to say anybody that would drive 3 hours to Belleville to have a conversation with somebody very briefly to say, hey, leave her alone. Couldn't pick up a phone and call them. But no, it's 3 hours there. And the other thing that's telling about it too is once he has his conversation, he follows Shauna back up to the room. This circumstance with Dylan Candidate takes place. What happens? Shauna leaves with him. Not sure if she was driving ahead of him or behind him, but she goes along. And I would argue to you that that is indicative of an individual that is very controlling. The defendant is very controlling of her. I would say, well, the iPad, there was nothing on there that says that he couldn't use the iPad or couldn't be at her residence. Well, what did Ms. Lavalette say? She said, he didn't have permission to be on my iPad. He had permission to be at my house. Well, no, counsel argues there's no evidence to show he's not supposed to be there. People 72 says he can't be there. It says right on there, not supposed to be at Ms. Lavalette's residence. and he's there. So this doesn't give him information that he shouldn't be there. I would argue to you, no, sure what would. He was already put on notice. He's not to be there. Once again, the argument is, well, how's he supposed to know he's not supposed to be on there? If he was correct in his assumption, you got to think about this. Would a reasonable person believe that Shauna Lavalette would allow him to get onto her iPad to find out where she was, to stalk her and track her down to Sanilac County without permission? I would argue to you, no, it's not the case. I was surprised that he was down at, or that Shauna was down at Dan Stevens. No, the whole thing could have been avoided. First, he goes into her house when he should have. But after he saw what he saw, according to his testimony, he went back home. He went back home, but you know what? He didn't want to do that because he wanted to follow through on what he told Dan Stevens before. That is that if I have to come back, you're not going to like it. So we get the argument that, well, you know, he went there and Mr. Stevens punched him as soon as he went on that porch. I'd argue you, the laws of physics cease to exist on the porch area of Mr. Stevens' residence. No. No. If he was truly punched like he said, with an outward swinging door, he's back on that porch. He goes in the house. And he goes after Mr. Stevens. I would argue that that is what the evidence shows here. Further, talk about Mr. Stevens. You know, the argument is he's had these 7 or so two-hearted ale. There's 7% alcohol. No, and he's drunk. He's drunk going after him. So we have a person that is argued to be drunk going after this individual who's into weightlifting and bodybuilding. One point, deadlifted over 500 pounds. Of course, he was squatting, according to the question I asked about the video on his phone, with his cast. He's squatting, but he's not steady on his feet. The guy was in a strongman competition. Would argue to you that out of the two, Mr. Stevens acknowledged he was drinking. He was in no shape to fight anybody, if that's the case, against this individual. Defendant didn't have any ability to retreat out of the house. He went into the house. First off, this all could have been avoided if he kept right on going and drive back home to his residence on. But he wasn't going to do that because he was going to send a message. And that's what he did. He stopped by the house to send a message. Well, there's no weapon the defendant has. Well, you got an individual with a cast from his wrist up to his shoulder. We know he can already do squats while having that cast on. I would argue to you, you know, when you look at some of this damage, we would argue that it was the defendant that caused that. Didn't hit Shannon. Well, I would argue to you that's true. But he put her in fear because of what he did to Dan Stevens and how he was yelling at her and he's in the closet. Miss Robertson indicated that, you know, this case got a lot of twists and turns. There's some disputes on things. Well, I would argue it's a very straightforward case. Very straightforward. The defendant goes to Sean's house. She's not there. Accesses her iPad, unauthorized. Finds out where she's at. Drives down to Sanilac County. Beats the hell out of the homeowner. Leaves in a hurry. Not blacked out, but leaves in a hurry because he believes the police are coming. And then goes and stays in Utley. Then the next morning, driving into work, going to drive by Shauna's house to see whether she's around. She turns out she's turning on the road behind him. Lets her pass, and then goes up to her and talks to her. And then after that, he stopped by the police. And all the while, this case goes on. Ladies and gentlemen, I ask you to find the defendant guilty of all the charges. Thank you.
Please be seated. Back on the record, please. On the matter of People versus Talisman, members of the jury, the court's been advised that is that members of the jury have reached a verdict in this case. Ms. Hatch.
Members of the jury, have you agreed upon a verdict? If so, who will speak for you?
I will.
Mr. Foreman, how do you find the defendant in file number 24-307158?
We, the jury, find the defendant, David Walter Talisman, as follows. Count 1, guilty of the offense of aggravated stalking. Count 2, guilty of the offense of using a computer to commit crime.
In file number 24-307178, how do you find the defendant?
We, the jury, find the defendant, David Walter Talisman, as follows. Count 1, guilty of the offense of home invasion first degree. Count 2, guilty of the offense of assault with intent to do great bodily harm, less than murder. Count 3, guilty of the offense of interfering with electronic device.
In file number 24-307184, how do you find the defendant?
We, the jury, find the defendant, David Walter Talisman, as follows. Count 1, guilty of the offense of home invasion second degree. Count 2, guilty of the offense of unlawfully accessing computers.
Members of the jury, listen to your verdict as recorded. You do say upon your oaths that you find the defendant in file number 24-307158. Count 1, guilty of the offense of aggravated stalking. Count 2, guilty of the offense of using a computer to commit a crime. In file number 24-307178. Count 1, guilty of the offense of home invasion first degree. Count 2, guilty of the offense of assault with intent to do great bodily harm less than murder. Count 3, guilty of the offense of interfering with electronic device. In file number 24-307184. Count 1, guilty of the offense of home invasion second degree. Count 2, guilty of the offense of unlawfully accessing a computer system. In manner and form as the people have in their information in this cause charge, so say you, Mr. Foreman, so say you all members of the jury.
Is that correct? Is that correct, everyone?
Yes.
No, I have to.
Okay.
Did I miss anything?
Ms. Roberts, would you like the jury?
Sorry, sir.
No, that's okay. Would you like the jury polled?
No, Your Honor.
All right, thank you. The court accepts the verdict of the jury, finding the defendant guilty of all the charges containing the respective informations and direct entry of judgment as to the charges contained in the information. Could I have a sentence?
Your Honor, August 11th?
Ms. Roberts, are you available?
Is it, I'm sorry, August
August 11th at 9 a.m. And if you're coming in from out of town, we can do it as late as 11.
I should be present, or by Zoom.
If your client agrees, your client has to be here.
Oh, yeah, of course. And, well, I can ask after the jury's excused. Other questions about probation and stuff.
All right, but you're okay with that date?
Yes,
Okay.
August 11th at 11.
Set sentencing for August 11, 2025 at 11 a.m. Prior to sentencing, I'm ordering a pre-sentence investigation report, which should be prepared, provided to both counsel and the court at least 2 days prior to sentencing. The sentencing guidelines shall be scored 14 days prior to sentencing and provided to counsel. Any objections to scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. As stated, the defendant must appear in the courtroom at time of sentencing. If there's any supporting documentation, it must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Mr. Rakowski, your position on bond.
Your Honor, the court has now heard all the evidence in this matter for both three files. And based on the severity of the of the attack and all the evidence that supports this matter, we ask that bond be revoked in all the cases.
Ron, my client has been here and done everything he's supposed to do since he's been released. He's got many things that he's gonna have to wrap up with his house. He's had no contact with any of the victims in this case. He's never received as much as a speeding ticket. I mean, he's got to close up his house. He's got other matters. There's not a doubt in my mind that he will appear. I'm asking that the bond be continued.
Thank you, Mr. Rakowski.
Your Honor, given the sentencing guidelines that apply in this case, a significant amount of time. And, given what we've seen during the course of the trial, as far as evidence-wise that's come in with this incident with Mr. Kennedy, with Mr. Stevens, and just with Ms. Lavalette and how things go, we don't trust the defendant out. We'd ask that bond be revoked.
Ron, this is, oh, he also has a GPS. Yeah, and I wasn't aware that he had a GPS. There's been absolutely no violation. He's made all of the appointments he needs to, pre-trial, whatever they've asked him to do, he's done. There's been no drinking. There's been nothing. He does need this time. He doesn't have a wife. He doesn't have a friend who lives with him. He's got a dog that he has to make arrangements with. He's got other matters. There's not been any kind of threat to anyone. And I implore that you allow him the next month and a half or 2 months so that he can get his affairs in order and have his ex-wife take his, put together a power of attorney so that she can finish up whatever else she needs to do to help him out. And he has a 7-year-old daughter that he would like to talk to about this and what goes on.
Thank you, Ms. Roberts. I appreciate that. Clearly, the defendants appeared at all court appearances. There's been no issue relative to that. And I don't see any issue regarding appearing in court. However, based upon the evidence the court has received throughout this trial, especially with the alleged incidents that were brought forth of location down in Metro Detroit area, as well as basically Forestville Road earlier, the court is revoking bond in this matter. The defendant is remanded to custody of the sheriff pending sentencing. That'll be all.